Counsel for Appellant Redding, you may proceed.
Good afternoon. My name is Suzanne Brandless, and I'm here today appearing on behalf of Zander Kelly, the appellant, who is also the father of Zavion Kelly. And I'd like to reserve 2 minutes for rebuttal, please. I'm going to start by addressing the issue raised by the court, which is the jurisdictional issue here. I believe that the appropriate standard of review for the jurisdictional issue raised by the filing of the notice of voluntary dismissal on January 6th is a de novo standard. It is a pure question of law. It's a jurisdictional issue, very similar to subject matter jurisdictional issues or personal jurisdictional issues. Now, with regard to my analysis of the case, obviously I've looked at the appropriate rule, Rule 1.420, and I focused on the section which talks about the circumstances under which there is an absolute right for voluntary dismissal by Ms. Colston, which is upon submitting a non-jury case, which this was obviously upon submission or before submission of a non-jury case to the court for decision. I believe that the operative issue here is the definition of the term court, and that the definition of the term court has got to be the ultimate trier of fact. If you look at the Fears v. Lunsford case, and its progeny is cited in my brief, you'll see that it is the ultimate trier of fact, whether it's the jury in a jury case, the administrative judge in an administrative case, if that's the person who's the ultimate trier of fact by statute, or the trial court. I believe in dissolution cases, the ultimate trier of fact must be by Constitution and Florida statute the circuit court judge. It cannot be a general magistrate, and we've discussed that at length in the brief. I want to bring up 2 points that are not in the brief that I think are very important for this court's consideration. One is the factual question. If you look at the record on page 43 and you look at the notice of dismissal, what you will see is that it was signed by Ms. Colston on January 6th. It was recorded by the clerk on January 6th, and it was recorded in the books and records on January 6th. I personally went through the file prior to the trial in March of 2007. There was no notice of dismissal in that file. I am not at all certain that Judge Reynolds ever saw this notice of voluntary dismissal before he entered his judgment on January 25th. There is nothing to indicate in this record that he saw it. There's no order that addresses it. His final judgment entered on the 25th doesn't notice it, talk about it, reference it. It was not in the file at the time of the hearing on the supplemental petition. It was only found when they were putting the appellant record together. And that's because there was a computer printout docket sheet which showed it, which caused the clerk to go back to the books and records.
I wonder if Judge Reynolds had taken this file up on January 6th, the same day she was filing her notice. Would the case be dismissed in your...
I think so, and I think that's because if you look at the facts of the Freeman case that I cited in my brief, there the trial judge had orally ruled, he'd ruled against the plaintiff. Between the time that he made that ruling and the time that he wrote his written decision, the plaintiff filed a notice of voluntary dismissal, and that was upheld as a valid notice of voluntary dismissal.
When did the hearing officer or the magistrate complete her recommended facts and conclusions of law?
I know that the hearing was December 16th of 2005. I believe that she wrote her...
Was that December 27th or something?
I think it was December 25th or December 27th. And as a result of receiving the recommended order of the hearing officer, Ms. Colston filed the notice of voluntary dismissal, which she thought was appropriate at the time to dismiss.
Now, the parties had 10 days to object, and if it was filed on the 27th, wouldn't the 6th be the 10th day?
Yes, sir.
And if, in fact, the parties have 10 days to respond to her recommended orders, wouldn't it be impossible for the circuit judge to have ever picked up this file and I guess ever been submitted to the circuit judge if, in fact, it wasn't within that 10 days? I mean, he could not have done it before that 10 days had run, could he?
Well, since everyone has 10 days to file their exceptions to a recommended order, I assume that he could not have done it before.
I mean, by statute, then, wouldn't it be fair to say that it was not submitted to the judge at least during that 10-day period?
I don't think it was submitted during that 10-day period, Your Honor.
I mean, it couldn't be by statute, could it? I mean,
she issued her report on December 27th. She had the hearing on December 16th. She issued her report on December 27th.
And mailed it to the parties, and they would have 10 days, right?
Yes, to file exceptions to it. However, my position would be that the right to file exceptions to the hearing officer's order does not preclude your right to file a voluntary dismissal, that they're two separate things.
Well, I mean, I'm just saying that if the judge had picked this file up on December 28th and said, okay, I have the magistrate's recommended findings of fact, recommended conclusions of law, and now it's submitted to me on December 28th, and I'm going to go ahead and make my decision, there would be at least an argument that the parties didn't have their 10 days.
Yes, sir, that's correct.
What's the point of your saying that the notice of dismissal was not in the file?
Because I honestly believe, Your Honor, I have very serious doubts.
Okay, assuming all that, so what? I mean, why does that matter?
Well, I think it matters because I think that all of the cases cited by both myself and by the appellee, there's a clear factual pattern that both either the magistrate in those cases or the trial judge in those cases were clearly aware that the notice of dismissal had been filed and that they either went to issue the final judgment or they did not.
Well, if the notice of are you saying that the notice of dismissal was not filed? Is that what you're...
No, sir. What I'm saying is clearly it was filed. We have the piece of paper that shows it.
And you're not arguing that it was filed sometime different than January 6th?
No, sir. I'm saying that I'm not clear that Judge Reynolds was aware it had been filed when he entered his final
You're just saying
judgment.
It was filed and it was nobody's fault that it wasn't caught. Is that what you're saying?
I'm saying it was filed, and the fact, and I don't know what happened to it after that, and I'm not sure Judge Reynolds saw it, and I think that is a significant fact.
Are you agreeing that by it being filed that jurisdiction was lost?
I believe when it was filed, jurisdiction was lost on January 6th.
And that means the parties are still married today?
Yes, sir. I believe that's the case.
And
now,
what about the wife? She engaged in a ceremony that she believed evidently was a marriage for a few months, what, in 2006 or I'm not sure. But
well, Your Honor, I think that happens all the time, unwittingly, and that is an unfortunate byproduct of this jurisdictional issue. She is no longer married to that gentleman.
But if she were, I mean, is this court, I mean, does it create jurisdiction because the parties thought that this order might be valid, even though you're arguing that the judge had, and if the judge has no jurisdiction to enter the order would not be valid, correct?
Absolutely correct.
So
yes,
are we saying that because the parties believed that the order was valid, it somehow, I mean,
no, I don't think the jurisdiction can be created by party belief. You either have it or you don't, and in this case you don't. And the fact that she acted upon it, well, that's unfortunate, but that should not affect your decision as to whether this notice of voluntary dismissal was valid. I want to move on to another policy question, which I think is very troubling, and that is, I think, based upon the decision in the Freeman case, I don't want to see this decision establish a two-tier type of justice. One tier for pro se clients who are, in our circuit, routinely sent to general magistrates for the report, to have the general magistrate argue the case, and then that be affirmed by a circuit court judge. And one tier where you have more rights to dismiss, where you are represented, you're not a pro se client, you go right to a circuit court judge and you stay there. And that's based upon the decision in the Freeman case. I think that is patently unfair, and it could be an unintended consequence of not finding that this voluntary notice of dismissal was valid. And finally, I think there's a very important policy issue, and that is we have a policy in the state of Florida to encourage reconciliation. Whatever Ms. Colston feels about being married to Mr. Kelly today, it is obviously very clear that on January 6th of 2005, she wished to remain married to him. And if you look at the comments to Rule 12.420, you see that the reason voluntary dismissals in all family law cases are non-prejudicial is exactly that fact. We want to encourage people to work it out, and we want to encourage people to stay together. I want to briefly move to the substantive issues if you find that the notice of voluntary dismissal was not valid.
Now, all those were abuse of discretion by the trial judge, weren't they?
I'm sorry, sir?
Weren't all those issues, were they all abuse of discretion, standard of review?
I'm sorry, I don't.
The trial judge, I mean, when we're looking at those issues, isn't our standard of review abuse of discretion?
Oh, yes, sir. Oh, clearly. The de novo standard of review only applies to the jurisdictional issue. It does not apply to any of the substantive issues that I'm going to discuss at this time. The substantive issues all turn on a change, substantial change in circumstance. And I believe that based upon Judge Reynolds' ruling at the hearing denying the motion to dismiss, the motion to dismiss was made by the appellee solely on the basis that we had not established a substantial change in circumstances, that the fact that the parties continued to live together a year and a half after the entry of the dissolution of marriage judgment did not constitute a substantial change in circumstance. I don't think you can square that up with his decision literally within 15 minutes that we had not proven a substantial change in circumstances for purposes of modifying the residential custody. However, if somehow you can do that, then I'd like to find out what the appropriate standard is to modify the original visitation schedule, which had reasonable and liberal visitation language, which Judge Reynolds, without making a finding of substantial change of circumstances or a finding that there was a benefit to changing the schedule, imposed in this case.
So you're saying that if he didn't find a substantial change of circumstances, he couldn't alter the visitation?
Exactly, because I think the Wade two-prong test, as I read those cases, the Wade Supreme Court case and its progeny, very clearly say you got to prove both prongs. So, okay, if I didn't prove a substantial change in circumstances, I don't think the court had the jurisdiction. The final judgment did not reserve jurisdiction to set a specific schedule. And if you read the transcript included in my brief, you'll see Judge Reynolds actually addressed that he said he normally did. In fact, put language in there when he didn't set a schedule, but the magistrate did this order and didn't include that. So it was not reserved. And I think without reservation of jurisdiction, he didn't have the ability to do that without meeting the Wade two-prong test. Thank you.
Counsel?
Good afternoon. May it please the court, my name is Daniel Blundy, and I'm a certified legal intern working at the Public Interest Law Center under the supervision of Ruth Stone, and I'm representing Clara Colston, the former wife, and appellee in today's case.
Is she the former wife?
I beg your pardon?
Is she the former wife?
I would like to argue that that's the case, yes. And speaking of that, we're going to talk about the jurisdiction issue, and I want to discuss some of the cases that appellant brought up in her argumentation. First of all, I want to talk about the de novo standard. We disagree that that's the standard that needs to be utilized in the discussion of this issue. Instead, we believe that this is also an abuse of discretion issue.
Jurisdiction is an abuse of discretion?
I believe so. I'm not considering it specifically a jurisdiction issue. Instead, I'd like to consider it to be an issue relating to the procedure employed by the trial court in granting a voluntary dismissal, as in Clara v. Pavlo last year in 2007 from the 5th District Court of Appeal. In that case, it was similar case was brought forth to appeal, and it was decided that was an abuse of discretion.
Well, let me ask you, if on January 7th or January 10th or whatever, they receive in the mail this judgment of divorce and they say, gosh, we thought we just missed this, we don't want to be divorced, they go back in front of Judge Reynolds on a motion for rehearing and they say, Judge, we just missed this, we don't want to be divorced. And Judge Reynolds says, nope, you're divorced. I'm not going to listen to you, I'm not going to hear it. And there was an appeal to us. Our standard on that would be, did the judge abuse his discretion in not allowing the party to dismiss their case?
Regarding the facts that you just set forth, it's clear from the record this is not what happened. That once Mr. Kelly and Ms. Colston were told at the courthouse that their motion to dismiss would not be valid, they did not go to Judge Reynolds and they did not ask him to nullify their divorce, and they did not say their marriage was not irretrievably broken, which is the standard that the Florida courts have shown in order to not have a divorce being given by the judge.
I wonder if Mr. Kelly had died in mid-January and Ms. Kelly or Ms. Colston went to the Social Security Administration and said, my husband is deceased and I want my Social Security benefits, which she would not have prevailed, I guess, under your, even though she dismissed the case, even though she thought she had the right to dismiss the case, she would not prevail, correct?
Well, unfortunately, I don't know Social Security law and the benefits with that, but on that point, whether or not she'd be able to say that she's currently married to Mr. Kelly, I believe at that time she would be. However, you have to realize that the important issue is the definition of when the case is submitted to the court.
Could the case be submitted to the court within that 10 days? I mean, you're not allowing the parties a 10-day period to respond to the...
No, not at all. That's not what we're saying. Parties are allowed to have that 10-day period in order to file exceptions. This was not an exception. They were trying to just dismiss the claim. And there were a few cases cited in my brief where people were filing a motion to dismiss, and they were not granted by the court because it was already submitted to the judge for its decision, which is what happened in this case. When the magistrate made the decision of the magistrates are analogous to those that are made in circuit courts when deciding whether a party can voluntarily dismiss their case.
That's really your argument, isn't it, that the magistrate, we ought to treat the magistrate exactly the same as a circuit judge. That's your argument.
That's an argument that we gleaned from a case in 2003, Solomon v. City of Miami from Florida District Court. And in this case, the facts were fairly similar. The court held that a summary judgment hearing that occurred in front of a magistrate ended the plaintiff's ability to voluntarily dismiss the case. And in this case, the incident case, the hearing in front of Magistrate Cloca Johnson on the appellee's petition for dissolution, the submission there ended the plaintiff's ability to voluntarily dismiss the case. And that's why, because the submission already occurred as far as all the facts being heard by the general magistrate, that's when that 10-day period started.
So what about the argument made by your opposing counsel that the policy considerations in the state of Florida, the policy has been established to favor reconciliation and the ability to dismiss the petition?
I will grant the fact that there is a stance towards reconciliation of policy, but I've got another extremely important policy goal that needs to be realized, which is that basically if you were to rule the way that they would like you to rule, then any plaintiff not agreeing with the general magistrate's order would be able to dismiss their case under Mr. Kelly's reasoning.
Well, Mr. Kelly could have, I mean, they could file a counter petition and not have their case dismissed. I mean, both parties can file a petition and there would still be a case alive. I mean, now part of the problem here is we have pro se individuals.
Right.
Your policy argument is that I go to the magistrate, I present my case to the magistrate asks questions, whatever goes on, right. I don't know, but after they walk out of that hearing, they're not feeling good. You're saying that as a matter of policy, they should not be allowed to walk into the clerk's office and say, maybe this isn't the best idea, let's dismiss this.
Yes, if I may, Your Honor, it's not just at that point, but they're asking to have the motion dismissed was after the general magistrate already had made her findings, and they were mailed to Ms. Colston and Mr. Kelly. And upon reading those findings, then the plaintiff could decide these findings aren't good enough for me. I'm going to have a motion to dismiss, and I'm going to.
But that argument may go more towards, and perhaps you could discuss that case you want to rely on a little more, but that policy goes more towards collateral estoppel and res judicata, doesn't it?
Yes, that's correct.
So in this case, you're saying that that judicial policy of collateral estoppel and res judicata outweighs the reconciliation policy considerations?
I believe that reconciliation is important, but it's another fact worth noting that these parties have been before Judge Reynolds many times, and it seems
But
like...
aside from the facts of this case, reconciliation is not as important as res judicata.
It's not just res judicata. That's not the only thing where the only policy consideration on that side of the argument. Furthermore, it's just judicial economy of people filing petitions and not getting what they want from the general magistrate. So they drop their case and they start all over again at the beginning, and they keep on going and going and going until they get a proper ruling from a judge that they would deem acceptable.
But couldn't, and I appreciate your argument, and it's very well put, but couldn't the subsequent judge find an abusive process if a person's trying to repeatedly dismiss? I mean, there are all kind of ways to address abusive litigation, including contempt of court, possibly. But I mean, I appreciate it, and you're doing a good job presenting the policy ramifications there. But the policy ramifications on the other side are pretty severe, right? A party cannot dismiss their own dissolution petition. They can't reconcile with their spouse. They don't control their own destiny.
No, I'm not saying that at all. They did control their own destiny. They just chose...
They lost control of it once it went to the general magistrate.
No, they did not.
They have to, I mean, under your argument, don't they have to, I mean, the general magistrate has to be the submission, doesn't it? I mean, you're not arguing that a party cannot dismiss their dissolution case, are you?
Right.
So a party can dismiss, and after the party dismisses, the court is without jurisdiction. You agree with those two premises?
That's right.
So the only thing that you're arguing is that once they sat in front of the special magistrate, or once she sat in front of the special magistrate,
the case is finally submitted to the
that
court.
case was submitted, and it was over.
Yes, that's right.
Even though there's not a final order.
It's not a final order, but that's when parties are allowed to bring forth their exceptions, which although they tried to bring out this motion to dismiss, they did not file any exceptions with the court.
So under your argument, the magistrate is greater than either the jury or the judge if they're the finder of fact, correct? I mean, in other words, if we start a jury trial and the evidence is coming in really lousy for me, and I'm the plaintiff, I mean, under the law, I have a right to walk into the clerk's office and file my notice of dismissal and say that wasn't going well. I'm out of here.
And there are consequences that flow from that.
Oh, certainly.
That voluntary dismissal.
But I can do that, right?
But that person can do that, right?
I'm not saying that general magistrates are above the law at all. I'm just saying that once the hearing is finally over and they take in all of the evidence and all the facts, and you were asking about the case I was referring to, it's Health Options v. Agency for Healthcare Administration, and this case dealt with an agency authorized to hold administrative hearings by the legislator, just the same way that the circuit court judges, they authorize the general magistrates to hear the cases in the courts. And a quote from the opinion is that to conclude otherwise, as you were saying, could effectively allow an objecting party to unilaterally terminate jurisdiction, which is basically my argument. And we don't want plaintiffs to be able to unilaterally terminate their jurisdiction. That essentially puts plaintiffs on a much higher plane than defendants in any of these cases because they could just terminate their jurisdiction.
Well, my point is that they already have that jurisdiction. I mean, they already have that power under Florida law. The plaintiff can dismiss their case at any point before submission, and the case law is pretty clear that submission is when the judge takes the case for decision. But up until that point, there can be evidence presented, there can be testimony, right? And in fact, a jury can be sitting there, and the jury can be listening, and the jury can be taking notes, and the jury can be conscientious, and the plaintiff can say, nope, I'm dismissing.
Yes, definitely that's the case in some situations, but I mean, I'm not sure if I already told you this point, but as the case quoted in Sheffield where the petitioners moved to dismiss their adoption case, it was at a third hearing where they failed to bring in a witness, and the district court held that the circuit court acted properly in denying their motion to make a final judgment. And that case had already been submitted to the court, even though there was a chance that conceivably more information could have been gleaned from other witnesses and whatnot, because the court felt at that time.
Now, when do we make the decision? I mean, because that was an adoption case, the judge made it right then. I mean, under your argument, the parties on January 6th did not want this to go forward. I think that's not disputed. I mean, she filed it. He said that he thought she was going to file it.
Well, there's conflicting testimony about that. It's kind of confusing. It seems like maybe both of them went to the court together. Maybe Ms. Colston went unilaterally to drop it off. But whatever the point, they both knew at that time that they were.
So your argument really is that Judge Reynolds could have said if they had, instead of going to the clerk and turning in this piece of paper, which is what they thought they had to do, which evidently had to do something more, but if they had actually gone up to his chambers and scheduled a hearing and said, Judge, we don't want a divorce, he could have said, too bad, you're divorced. Now leave, get out of here, don't, you're divorced. And that would not be reversible on appeal.
He could have heard their testimony at that time, but they were advised of that hearing when they received the ruling from the general magistrate through service. And they knew when that hearing was going to be taking place, and they could have gone to Judge Reynolds and they could have spoke to him, but they chose not to. Once they incorrectly tried to do a motion to dismiss, they were told that was the wrong thing to do. They knew that if they didn't do anything, they were going to be divorced, and they just chose to do nothing. And so that's why the divorce went through, and both parties relied on that divorce.
You're not arguing for a common law divorce, are you?
No.
I mean, the fact that she got remarried, or they relied on it, or they thought, is any of that relevant in your argument?
I believe it's important to note that both parties were relying on it.
But what legal effect does it have? Because for it to have legal effect, it would seem to me that what you're really saying is that we have to have common law divorce in Florida. And when we specifically got rid of common law marriage, because we want there to be some kind of formality and some kind of identifiable ceremony.
Right. It's because of the formality of attempting to have the motion to dismiss and being told that it was denied, and they both knew it was denied. They both felt that it was divorced. I realize I've only got a couple minutes left. I'd like to, in case you decide not to move on this issue, to briefly go over the other issues that were brought forth.
I think Ms. Stone's trying to get your attention, or I'm going to give you 2 extra minutes, and I'll give the other side 2 extra minutes on rebuttal, okay? Ms. Stone, I'll allow you to appear before the court if you wish. Okay.
Thank you. It looks like one thing I may have not completely got across is that after the general magistrate submits their findings of fact to the judge, it's not just a de novo review where the parties can go up to the judge and say whether or not they want to get divorced and re-put forth their testimony. Instead, it's basically an abuse of discretion standard for the general magistrate, whether or not the general magistrate abused their discretion in granting the divorce based on the facts that were submitted to him or her.
Well, the reason I had mentioned the 10-day submission period is it really ties in, I think, with the circuit judge's responsibility. I mean, the rules and the Supreme Court has been clear. It's not just a rubber stamp. And if we give the parties a chance to respond to what the special magistrate says, then it would seem as though it would be impossible for the case to be submitted if there's still this period of time for the parties to submit things that they would like the judge to consider when the case is submitted for final resolution. That was only my point. I mean, I realize that it's very difficult to get something different.
I think I see what you're saying, but I think you're making an assumption. Correct me if I'm wrong. I think you're assuming that Judge Reynolds definitely did not see the motion to dismiss, but this is merely speculation, and there's no proof that the judge got the file early, that the judge got the file before 10 days, especially since I believe the date was January 25th, where he finally put in the final order. That was definitely much more than 10 days after the deadline would have passed.
See, I'm kind of thinking that the party has an absolute right to dismiss their case up until the time of submission. And once they dismiss, it doesn't matter what Judge Reynolds wants to do or doesn't want to do or what he sees or what he doesn't see. It's gone. If it's dismissed and it hadn't been submitted, that's...
I understand what you're saying, Your Honor. Our position on that is that, as I stated before, because of collateral estoppel and plaintiffs being able to just retry their cases when they already find out what the general magistrate ruled on, and the cases I quoted earlier, both Sheffield and Health Options, they both dictate that it's in the court's best interest and the state's best interest to have those general magistrate decisions as the court states to be followed.
To control over efforts at reconciliation or dismissing the cases.
Yes, Your Honor. With no further questions by the bench, once again, I respectfully ask that you affirm the final judgment from the circuit court in this case. Thank you.
Counsel.
I'm going to quickly sum up here. The standard for all jurisdictional issues is de novo. The Collado case referenced, if you look closely at that case on page 70, you'll see that the parties are in agreement. So the parties in the Collado case agreed that they would review both the procedural issue there and the substantive issue there under an abuse of discretion standard. Clearly, we're not agreeing that an abuse of discretion standard is appropriate here. I think what this comes down to is who is the ultimate trier of fact.
What about their argument that the circuit judge doesn't look at that de novo, that it's an abuse of discretion standard when the circuit judge looks at the factual findings by the magistrate? Is that true?
It is an abuse of discretion standard, but that has nothing to do with jurisdiction, Your Honor. In other words,
the jurisdictional issue arises of, whether or not it's submitted to a fact finder or not. Their position is the magistrate's the fact finder, and you get there by saying it's a different standard that the circuit judge looks at it.
And my position is that that's absolutely incorrect. My position that is if you look at the case laws under the Fierce v. Lunsford, which gives us an absolute right, gives the plaintiff an absolute right of dismissal, you have to focus on who is the ultimate finder of fact. And it is patently clear under Article 5 of the Constitution and the statutes that only a circuit court judge can enter a dissolution case.
Regardless of the standard of review.
Regardless of the standard. And I also want to say I don't think judicial efficiency, I don't think res judicata trumps lack of jurisdiction. Jurisdiction is a fundamental issue, and it must come first. And I also want to say this is not a case in which Miss Colston, by filing her notice of voluntary dismissal, was somehow trying to get something she hadn't already gotten. Look at the report from the general magistrate. She got primary custody of the child, liberal and frequent visitation. She was asked if she wanted child support and said...
But all that's, in your argument, all that's irrelevant.
Exactly. That's exactly my point. I mean, and my point is this is not a plaintiff who was disgruntled and filed a notice...
But, I mean, that's irrelevant, too. If she filed a voluntary dismissal, it was dismissed.
Exactly.
In your argument.
Yes, sir.
Whether she was extremely happy, whether she really did want a new review, whether she was playing games in the system, your argument to be crystal clear and to take into account your opponent's argument is, quite frankly, let's assume she was an abusive litigant, and she got factual findings that she didn't like.
She still has a right.
You say she still has a right to dismiss. That's it. Game over. And I assume your primary argument is lack of jurisdiction, and your backup argument is a policy considerations favoring reconciliation.
Succinctly stated, Your Honor. I have I'd be happy to answer anything else or to close.
Thank you, counsel.
Thank you so much, sir.
Court is adjourned.